Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. The other day I uploaded a video with instructions on how to file a lawsuit after having been denied your Social Security and how to appeal. And in that video, I talked briefly about the role of the administrative law judge and his or her role in determining whether the applicant's application should be approved or denied. The administrative law judge has a duty to weigh the evidence before making the decision. So let's get started. And we're talking about litigation on the federal level. Administrative litigation is typically a type of proceeding that is brought to seek review of an agency's decision, whether that decision is to grant or deny a permit or a license or an approval or a rule. There are regulatory cases. These cases involve challenging a rule or policy that was created by the agency. And then there are entitlement cases. These cases involve public benefits, for example, disability benefits and workers' compensation benefits. And I like to go over some roles that the administrative law judge engages in. An administrative law judge, first of all, is an independent hearing officer. What does that mean? That the judge presides over administrative proceedings for the federal government. The judge is appointed by the heads of executive agencies. The judge is considered part of the executive branch. The judge presides over trials and adjudicates claims or disputes involving administrative law. And the judge can administer oaths, take testimony, rule on questions of evidence, and make factual and legal determinations. Versus the Article 3 judge, who is nominated by the President of the United States and confirmed by the Senate. An administrative law judge is hired and placed by the Office of Personnel Management as merit employees through specifically designed competitive examinations, as in the case with other federal merit employees. And in ruling on questions and evidence and before making factual and legal determinations, the administrative law judge is required to weigh the evidentiary material or evidence. So to illustrate this point, let's look at Lewis versus Berryhill. The plaintiff, Diana Lewis, applied for disability benefits with the Social Security Administration. The SSA denied her application. Plaintiff appealed the denial by suing the commissioner of the Social Security Administration, Berryhill. At the time the plaintiff files the lawsuit, the individual will be suing the commissioner of the Social Security Administration, whoever that commissioner is at that time. So let me give you a backdrop on this case. The question is, if Ms. Lewis was unable to perform work in the national economy, her application for Social Security benefits would be granted. To assist the court with this determination, Lewis's physician, Dr. Kenneth McCullough, presented an assessment of Miss Lewis's medical record to the administrative law judge. Dr. McCullough treated Lewis from May 2010 to November 2011. At issue is the weight the administrative law judge gave to Dr. McCullough's assessment. The administrative law judge rejected the doctor's assessment and failed to give it weight, thereby affirming the Social Security's denial of her application for benefits. Lewis appealed to the circuit court. So the question is, did the administrative law judge apply the correct legal standard? If no, a reversal is necessary. So let's look at the standard for the administrative law judge. The administrative law judge uses a preponderance of the evidence standard when making a decision as defined in 20 CFR 404.901 and 416.1401. A preponderance of the evidence means that after considering the evidence as a whole, the existence of the fact to be proven is more likely than not. And you will find this information also at what we call HALEX. Now, that's an abbreviation for a manual associated with the Social Security Administration. And that's HALEX I-334. A part 2 question is, did the administrative law judge comply with the standard? If no, a reversal is necessary. So I'm going to ask you to pause the video for a moment here. Before you read the court's ruling, what do you think? But I want you to consider the standard. Before you assess the decision made in your case, you want to know what that judge's standard was. That's important. But based on what you've read and heard so far, what do you think? You just read what the judge's standard is. Did the judge comply with that standard? What do you think? Let's see what the appellate court found. The court held that the administrative law judge gave Dr. McCullough's assessment no weight, and in doing so, the judge erred. The court opined the administrative law judge had an obligation to weigh Dr. McCullough's assessment based on the regulatory factors at CFR section 404.1527C. The judge could comply, the court said, by giving Dr. McCullough's assessment no weight, but if the judge did so, he would need to give reasons that were both legitimate and specific. And this section, by the way, 20 CFR section 404, is the Social Security Administration's standard. So knowing the standard is critical. You see that? So the court held that reversal and remand are necessary based on the absence of specific legitimate reasons to reject Dr. McCullough's opinion. So on remand, the administrative law judge would get an opportunity to specifically state why he rejected Dr. McCullough's opinion. So always look to the standard to determine if the judge complied with the same. Because if he or she didn't, that's a potential ground for appeal, as was just demonstrated here. Okay?